Your names, please.
Jonathan Samuels.
All right.
Steve Magus, Your Honor, attorney for the personal representative of the estate of Earl Samuels, Tim Flynn.
Okay.
This courtroom showdown wastes no time pulling us straight into a legal storm. Judge Simpson calls for names, but don't be fooled by the calm start. What follows is a clash of property rights, probate law, and accusations of disrespect. On one side, attorney Steve Magus represents the estate, and on the other, we hear a voice fighting desperately to preserve what he believes is his rightful claim. Already, tensions surface around notices of eviction, missed communications, and the haunting question of whether legal safeguards were ignored. The stakes, ownership of a farm tied deeply to family history. This isn't just about property, it's about legacy, memory, and the thin line between legal authority and personal betrayal. Think about this. How often do courtroom rules clash with human emotions? And who do you trust more? The paper trail of court filings, or the lived experience of someone saying, "This was my home"?
Couple of things, and the reason that the court set this hearing. We have checks in place to try to make sure that documents aren't filed. I'll say in violation. I'm not saying that using the word that it was intentional necessarily. All of which includes the court officer, all of which seem to have not taken place. But the question for the court is frankly, I don't know that this writ should have issued in the fashion that it did. Maybe for not, but ultimately, but it should not. First question I have is, the documents we had indicated that the writ was executed.
Yes, Your Honor.
Okay.
Without any notice.
Well, there would have had to have been notice because there should have been 72 hours notice.
Judge Simpson zeroes in on a critical safeguard, the 72-hour notice rule. In eviction law, this isn't just a procedural nicety, it's a lifeline. That window gives residents time to prepare, remove belongings, or contest the action. But here, the defendant claims he was blindsided, that attorney Magus knew exactly where to reach him but chose not to. This accusation of deliberate silence transforms what might look like a simple misstep into a pattern of alleged disrespect. For viewers, this raises a vital question. Is this incompetence or calculated exclusion? Courts thrive on documentation, yet what happens when procedure is weaponized against someone's living reality? Drop your thoughts in the comments. Do you think failing to notify someone properly is grounds to void an eviction, or is it just an unfortunate technicality?
They put a notice on the house, but he knew that at the time I wasn't staying there. He knew where I was. He didn't email me or
Who knew?
Attorney Magus.
Well, all of the orders of eviction which I sign and send out, and I'm the one that does it, there's a 72-hour posting. So it's posted, it won't be executed for 72 hours. Are you saying that didn't happen?
I imagine, no, they put a notice on the door when I saw it, when I went there afterwards, that the notice on the door was dated more than 72 hours before the action that they took. So they did that, but the point is, Attorney Magus has been in communication with me about a lot of things. Deliberately didn't tell me they were doing this. He deliberately didn't tell me they were towing my cars. It's representative of how everything has gone and his lack of respect for my devisee ownership right, and the fact that I told him from the first moment I talked to him, now nearly several months ago, that buying the farm was the most important thing to me, and he's done things which have very much hurt me and my ability to follow through on that.
Here's where emotion collides with law. The defendant insists the attorney's actions undermined his dream of buying a farm, something he describes as the most important thing to him. This isn't just a legal fight, it's deeply personal. His voice cracks with frustration, painting a picture of someone locked out, cars towed, and dignity stripped away. From a legal standpoint, the court must ask, do these claims prove intentional misconduct, or are they grievances that fall outside the technical boundaries of law? But for the audience, the human weight is undeniable. Imagine planning your future around a family property, only to feel shoved aside by procedure and cold paperwork. This moment forces us to confront a haunting question. Can the law truly capture fairness when legacy and livelihood are on the line? Would you see this as justice served or justice denied?
So this is just one of, he also locked me out of the house where I was staying at the time on June 30th, my parents' house in Farmington Hills, without notice. So he has a pattern of doing things just that are easy for him. But, and then he tries to say I wasn't staying there all the time, even when, as he saw, my things were there, my food, my computers, my documents, my, I mean, so and now they're saying that I like never lived at the farm. I did live at the farm in the past. I mean,
There's a big story here that we could take up the rest of your afternoon, and then some with regard to the administration of Jonathan's parents' guardianship and conservatorship, and now their probate estate. I'll try to keep it on the main points that relate to this case. The property that we're talking about here has been approved for sale by the Oakland County Probate Court.
And here comes the bombshell. The probate court already approved the farm for sale. This reframes everything. For the estate's attorney, this isn't about cruelty or shortcuts. It's about clearing legal roadblocks to execute an authorized sale. But for the defendant, it feels like erasure, the farm slipping away under the cover of legal process. The tension here captures the duality of probate law. It exists to distribute estates efficiently, but it can crush those with sentimental or contested ties to property. Think of it like two competing clocks, one ticking for orderly administration, the other for human attachment. The attorney tries to keep it clinical, citing judgments and deadlines, while the defendant clings to legacy and memory. Here's a question for you. If a property tied to your family history was lawfully approved for sale, would you fight tooth and nail or accept the court's authority?
Got it. Before the probate estate of Earl Samuels was involved, a judgment was issued that advised Jonathan, I think it was the end of 2023, that any personal property that he wanted to remove from the property, he needed to remove by, I think, the 12th of December, 2023. We had several of these judgments with regard to estates and properties, okay? And I applied for orders of eviction on all of them, just to simplify the contingency that Jonathan has a pattern of anytime we try to sell a house, he says he lives there and he moves in. So I learned thereafter about there's potentially a court rule that says it has to be 56 days.
Yeah.
It wasn't that intentional. It wouldn't be the first time I've learned in real time about a court rule. But the reality is Jonathan doesn't live there, and he's using this as an opportunity to effectively appeal the probate court's decision to allow the sale.
Which was based on misrepresentations, many of which by Attorney Magnus.
All right, so I'll let you talk, sir, but I'm
sorry, Your Honor.
going to have parties interrupting. Let me just say this, I'm not going to get into anything that the probate court does. If I wanted to be a probate court judge, I would have done it. So I'm not going to do that. All right.
Judge Simpson draws a hard line. He's not here to second-guess probate court decisions. This is a crucial boundary in the legal system. Each court has its lane. Probate handles estate distribution, district courts handle eviction procedure, and crossing wires creates chaos. But notice how the defendant keeps dragging the farm sale into this hearing. It's his emotional anchor. Judge Simpson's refusal underscores the cold compartmentalization of law. To the audience, it may feel heartless. Why can't the judge consider the bigger picture? But this is how judicial efficiency works. One court doesn't trample another's jurisdiction. Still, the optics are dramatic. A man pleading for legacy, a judge brushing it aside as not my lane. Do Do you think strict separation of authority helps keep justice clean, or does it blind courts to the human reality unfolding before them?
The issue that I have in this case, and like I said, there are a number of checks in our system, all which failed, is that there would have needed to be a hearing prior to the issuance of the writ. It becomes a little bit more concerning based upon the documentation that I received today and reviewed, that the defendant does not reside at that address. That's what I received today from, I think, the individual who is a conservator of the estate or the personal representative, which maybe means that the issue is moot, or maybe not, because, sir, you're claiming you reside there.
At this point, the case sharpens to a single question: residency. Did the defendant actually live there, or was he leveraging occupancy claims to stall a property sale? Residency is more than an address. It carries legal rights, obligations, and protections. If he resided there, eviction rules change dramatically. If not, the estate has firmer footing. Judge Simpson knows the difference between visiting occasionally and legally residing is the fulcrum on which this case pivots. For the audience, this is where emotions blur into evidence. Clothes, food, documents. He claims they prove residence, but courts demand more. Mail records, utility bills, consistent presence. What do you think? Does leaving belongings somewhere equal living there? Drop a comment, because judges wrestle with this distinction every day.
I'm claiming that I resided there in the past, that there's things of mine there, and that they still need to go through some process because I have rights. Because especially now that there is an estate and I'm a 50% advisee, that they can't just, without any notice, decide to try to have something enforced that's actually a totally separate action. Nearly 2 years ago, it's obviously no longer the conservatorship, and I didn't have any ownership right then. So it's, the law is actually that ownership passes at the time of death. It's just subject to administration, and then it gets backdated, sort of. So I have a legal interest that I did not have in the farm almost 2 years ago. And in fact, I told, as I say, Attorney Magdis how important it was. And he refers to me not moving things out. Well, what I told them nearly 2 years ago was I was determined that the farm wouldn't leave the family. So Dad didn't want it to leave. He had testamentary capacity. All of this has taken place because people don't respect even the proper procedure.
Sir, I'm just gonna stop you, because you're getting into issues of which this court doesn't have jurisdiction over.
Right, but it did have well, and there's actually some question of whether it even has the authority to evict someone in a situation like this. Some things that I was studying today, and I actually filed something additional with the court because of my ownership interest as an advisee, that it's not even necessarily subject to the same landlord-tenant eviction procedure as Attorney Magdis.
Here's a fascinating twist. The defendant argues this eviction doesn't fit normal landlord-tenant law because it involves an estate. That's a clever legal angle. Probate evictions aren't as straightforward as rental disputes. They straddle property law, inheritance rights, and probate administration. Essentially, he's saying, I'm not a tenant, I'm an heir with ownership rights. That could force the court into a gray zone because probate heirs often hold different protections. This is where law students would perk up. It's textbook complexity. But to viewers, it feels like someone desperately throwing every legal theory at the wall, hoping one sticks. Is it strategy or stalling? You decide. Would you frame this as a valid defense or just an attempt to drag the process out? Either way, it shows how estates can become battlegrounds far beyond wills and inheritances.
Had enforced inappropriately. So it's complicated. And Attorney Magdas and now my sister's attorney want it to be simple. And it's representative, as I was starting, of many things that have happened over the past 4 years. Because my parents were clear on what they wanted. My dad was clear on what he wanted for the future. And for the farm to be sold like this is horrific. And the fact that.
But sir, just stop for a moment. The sale of the farm, as you're indicating, again, is not something that is
Right.
within my jurisdiction.
That was my next sentence, but your signing this order was an essential step in them selling the farm. So.
And it may very well be, but what they do with the property after an eviction, I'm not part of it. I don't know. On the numerous cases I've had today, there are eviction orders that are issued. What then the owner or the person in charge or with authority over that property does, I don't deal with.
For sure.
Judge Simpson's blunt here. Once an eviction order is signed, what happens to the property is not his concern. That's a cold reality of the system. Judges authorize possession changes. They don't babysit how estates use the property afterward. For the defendant, though, that distinction is everything. He sees the eviction order as the crucial domino that triggers the sale, making the judge complicit. Simpson pushes back, clarifying his limited role. This moment highlights a fundamental truth about courts. Authority is fragmented. One ruling here, another ruling there. Each judge only controls a piece. To the audience, it can feel maddening. Why can't one judge just resolve the entire dispute? But the structure is intentional. It prevents overreach. Still, ask yourself, does this kind of compartmentalization protect fairness, or does it allow injustice to hide in the gaps?
I'm just asking for you not to issue an order of eviction in this case, especially because there's multiple reasons not to issue it. Both the fact that, as you say, they didn't follow the regular rules the way they're supposed to, initiating a new proceeding if they were going to argue that eviction was the way.
Well, they wouldn't be required to issue a new proceeding. There would need to be a hearing prior to the issuance. But then the information that I've subsequently received may have the ultimate result of that be moot. Because the real issue is at the point, there's a time limit from the point of the judgment to the issuance of the writ, and then how long the writ then has to be executed. There are 2 56-day periods. Here, the first one, in terms of having a hearing, wasn't complied with. The question becomes, at least in my mind, is, do I order you restored to the premises, or do I not?
This is the heart of the drama. Judge Simpson weighs the ultimate question: should the defendant be restored to the farm? Restitution of possession is no small matter. It can reverse the trajectory of the estate, stall the sale, and reignite family conflict. On one side, restoring him may uphold fairness if procedures were botched. On the other, it risks enabling obstruction and further delay. It's the judicial equivalent of rewinding the tape. For viewers, this is a cliffhanger moment. Will justice lean towards strict process or human sympathy? Courts often balance harm. Was real damage done? Or is this a technical misstep with no lasting consequence? Imagine being in the judge's chair. Would you hand back the keys to someone who may not even live there, or let the sale move forward unchallenged?
Or do you restore?
I would say it's simpler than that to just vacate or stay your eviction order, because there's
Can I just say this? by what you're telling me, and I don't know this for sure, but certainly the information that I received was that you were not residing at the property.
Not,
Things you're saying to me right now lead me to believe that you weren't residing at the property and that there really hasn't been any harm by the execution, because you keep talking about something that has occurred as though it hasn't occurred.
no, they definitely caused harm. They already towed my vehicles. They broke into the house. They didn't give me any notice that I needed to work to remove, because they're actually, even though the house, I mean, there's things of significant value there that Attorney Magnus is not aware of.
If it's helpful, Your Honor, with regard to the substance past the procedure, he can have everything in the house. It's a hoarder house. You can't even open the door. It's actually dangerous, which we're a little bit worried about, but if he's willing to waive liability, he can go in and take whatever he wants. What we're trying to avoid is him getting back in there, claiming he lives there and stopping the pending sale.
The estate's attorney reveals their deepest fear that restoring possession would give the defendant a foothold to derail the sale. This isn't just paranoia, it's a strategic reality. If he regains access, he can physically block showings, complicate title transfers, or restart legal battles. To the estate, this isn't about fairness, it's about preventing sabotage. But from the defendant's perspective, this argument paints him as manipulative, stripping away legitimacy from his claims. Here's where narratives clash. Is he a rightful heir defending his stake, or a spoiler abusing process? This tension is why courtroom drama captivates us. It's not just law, it's storytelling, where each side crafts a villain out of the other. If someone regains possession solely to stall a sale, should courts treat it as abuse of process, or as a legitimate assertion of rights?
So,
Okay, so let me just say this. Although the eviction was executed, there was property that was not removed from the premises as of yet.
the only property that was removed from the premises is 2 derelict vehicles that were towed and are available for Jonathan to pick up. They were,
Okay, but those were on the outside, those were on the premises, but not inside the house.
yes.
But as far as things in the house, nothing was removed.
Nothing was removed from the property.
Correct.
Okay, that's
not true.
makes it
They
easier for me.
moved things out on the front yard. They took some things. I mean, I wasn't there, but it looks like they took some things away. Because they scattered stuff on the lawn and out by the curb.
Here's what I'm gonna order at this point to try to correct the 56-day issue, as well as to try to address whether or not then there's sort of this clear path to the estate doing what it wants to do. I'm going to set a hearing. So while it's after the fact, the very fact that things have not been removed is fine. My determination will be whether to allow the execution of the writ to stand. And in that respect, the property inside, you can let him in or not, if that's the way I rule. Or that you would at least for a time period be restored possession of the premises subject to the hearing and then the court's issuing of a new order of eviction. And that's the best I can do to kind of remedy the circumstance. Quite frankly, it's a little bit easier than I thought because stuff hasn't been moved. So it's easier in that respect. It's also maybe easier in a certain respect. I don't think you were residing there. So it's not like I took. Sir, please.
I'm sorry, Your Honor.
It is not as though there was for lack of a better term, a household that then is completely taken out, and this is a different scenario. So we will have the hearing, and I will either allow the execution to stand or put it back in. That's how I'm going to handle this. And so, when's my next
The time issue though is.
I'm sorry, sir.
That I would have, if he would have followed things, I would have had more time to deal with. There's things there that would take me some time to move. Is the
But sir, okay, let's just go with your hypothetical. Had that happened, they would have requested a hearing because it's afterwards. Let's say at that end of that hearing, I permit the issuance of the writ. Okay, just hypothetically, let's say we had gone through that whole process. And let's say they brought their $15, they brought the writ or the order of eviction in, I sign it that day. They get the officer to go out there, post it. You're going to have the same time frame. You're going to have those 72 hours prior to then the execution of the writ. So in terms of your argument regarding time, it's not an argument for the court.
Wouldn't there have been time before the hearing that I would have been notified of the upcoming hearing?
Right.
So that's the most significant time. Because
Are you listening to anything I'm saying?
I definitely am. You said that the order of the writ would be 72 hours, but I'm talking about before that, before you would potentially issue the order, the time between being notified of the hearing and actually having the hearing. And I don't know.
Okay, so here's what I'm going to do. Listen real carefully. I think counsel gets what I do. I'm going to set a hearing. Normally what the hearing would have been, had it occurred in its order, would have been a determination as to issue the writ or not. I will set that hearing, although it's seemingly after the fact, there isn't much harm or any harm because I don't have a household that's displaced. What I really have is a circumstance where they've taken possession of the premises. Things have not been removed. And then I will make that determination as to whether or not that writ will stand or it will not stand.
This moment is pure suspense. Judge Simpson announces a future hearing where he'll decide whether the eviction stands or gets vacated. It's a judicial reset button. Notice his tone measured, almost surgical. He acknowledges mistakes in procedure but insists the harm may not be as great as claimed since most property remains untouched. For the defendant, this is both a lifeline and a trap. He gets another shot, but it's tightly scoped. For the estate, it means weeks of uncertainty and potential delay in the sale. The brilliance here is procedural fairness. Simpson is restoring balance without prematurely siding with either camp. Think of it as a courtroom cliffhanger. Who wins depends on the evidence presented at that hearing. Viewers, if you were in his shoes, would you let the eviction stand or wipe the slate clean?
You follow that?
Yes, Your Honor. I just thought that there's requirements of notice before such a hearing.
I am about to set a date and that will be your notice.
And what would the date have been if they just started prep?
Sir, yeah, okay.
I'm
Wait.
sorry.
I'll give that to you. Hold on one moment. What did I say, 16? Okay, so here's what I'm gonna do. I'm gonna set it for the 16th. Okay, in person at 9 a.m. Now, we're on the 5th. So that gives you now, from the court's final ruling, 11 days. So your question is whether or not that in some way penalizes you. Actually, you benefit from it. Because had they filed the motion or the request for hearing prior to, had they mailed it to you, they could have had a hearing in 9 days. If they had personally served you, they could have had a hearing in 7 days. Here, that's the notice you would have gotten. Here, you're getting 11 days.
Okay, Your Honor, but would that have been a hearing based on the previous filings? Because that's my basic contention
Previous filings of what?
that led to your judgment in December of 23.
I don't know what that means.
They're attempting to continue something that isn't. So I'm not sure how the procedure would work if they didn't have the December of 23 record and your,
You are truly not following this, are you?
I'm sorry, Your Honor, I'm just thinking.
No, you're creating difficulty where there is not difficulty. And you're not listening to what I'm saying. Because what I'm telling you is that on the 16th, I will make a determination as to whether or not the writ stands, or whether or not that writ is then the execution thereof is squashed and you're restored possession of the premises.
Okay, thank you, Your Honor.
That is the same decision, quite frankly, that had they filed the 56 days and it, had they filed for the hearing, that is basically the same determination that I would have been making. Could they have the writ, or do they not get the writ for whatever various reasons, may have to do something else?
What's the reference to 56 days? That's what I don't understand.
There are two 56-day periods in landlord-tenant law. First is that a judgment must issue within 56 days of its rendering. Has to be signed. The second is that a writ, well, actually, that first one isn't really necessarily a 56-day. After the judgment, the writ of restitution or order of eviction cannot issue 56 days, more than 56 days after, without a hearing. And then once that issues, that the second 56 days is that writ must then be executed within 56 days of.
Oh, it's okay. That's what I didn't understand. Okay. I thought it was a after. It's a within. Okay.
What's a within?
The 56 days that you refer to are periods within which something must occur. I thought they were periods after.
Okay, so that I'm not going to sit here and go into some huge legal argument with you.
Okay.
It's the 56 days where things can happen automatically without court intervention. Let's do it that way.
Thank you.
All right. So while that happened in this case, I am in the writ was not executed in its traditional sense because things were not removed from the premises, and I will take counsel's representation as an officer of the court. That has not occurred. So then the question becomes, really, just to break it down to you, make it easy. I'm going to have the hearing on the 16th for a determination as to whether or not I allow the order of eviction to stand or whether or not I vacate.
Thank you, Your Honor.
So I will set that hearing September 16th, 2025 at 9 a.m. That will be an in-person hearing. Provide to the court whatever you wish the court to review prior to that time. And I will also review what I need to at that hearing and make my determination. Thank you,
Things
Your
will
Honor.
still be here, or will eventually you be in Saline?
Pardon?
Things are always going to be here, or will you eventually be in Saline?
It will always be where I am. So I am here. So it will be here. I will let you know that on the 16th, it won't be in my courtroom, courtroom C, it'll be in courtroom A on that date. Because it'll be
You're always here. Some things are out of the 14A4 in Saline.
14A4 hasn't been open for almost a year now, sir.
Okay, I'm unaware of everything. I'm sorry.
Okay,
Should I prepare an order, Your Honor, or will the court? Thank you.
we're good. We'll have to hear. All right, thank you.
Thank you.
Yes, it is. Good things in recess.
And there it is. The gavel moment, not in finality, but in pause. Judge Simpson sets the next hearing for September 16th, where the ultimate decision on eviction and possession will be made. This professional handling shows the balance between rigid rules and human disputes. He recognizes procedural failures, yet refuses to be swept away by emotion. For the defendant, the farm remains just out of reach, suspended between hope and loss. For the estate, the sale hangs in limbo, waiting for judicial clarity. What's at stake isn't just property, it's legacy, trust in the courts, and how far legal battles can stretch family fractures. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.